And finally, it is showtime. Good morning, everyone. I want to thank you all again for attending Department of Buildings Construction Code Development Listening Session, with today's topic being building and existing building codes. Before we begin our session today, we just wanted to go over some training rules so that way everyone has an idea of how today's session is going to go. And we will then pass off to our host of the day, Mr. Nev Jordan. So, just some house rules that we would like to go over just to ensure that everyone has an understanding and an awareness of how today's webinar will go, as well as ensure that we have a smooth listening session today. So, all attendees will be muted during the presentation, and you will only be able to see the content being shared, as well as the DOB panelists attending today's listening session. As the presentation concludes, we will have an opportunity at the end to allow everyone to provide feedback on the information that was shared today. All we ask is that you please raise your hands, and then you will be sent an invite to unmute your microphones. Once your microphones are unmuted, you will have an opportunity to engage with our panel. So without further ado, I would now like to pass off today's listening session to our host, Mr. Nev Jordan.
Thank you so much for that introduction, Ashley. Good morning, everyone. Today is July 9th, 2026. Thank you for attending the DOB's second Construction Code Development Listening Session, as this one is focused on building and existing building codes. My name is Nev Jordan. I am an outreach specialist, and I will be joined today by a few helpful people. First of which is Strategic Enforcement Administrator Keith Parsons, Chief Building Official Nicole Rogers, and Chief Inspection Official Peter Nyagabosi. I'll be facilitating this listening session to ensure everyone has a chance to share their feedback and that we're keeping an eye on time. As Ashley previously stated, please raise your hand to speak, but you may also make use of the chat box. To ensure ample time for all attendees to share, please try to keep your feedback brief. And remember, this listening session is designed for you to explain how the codes have impacted your work, your life, any sort of unique challenges they may have presented you with, and anything else that you would like to share. Before we get started, I'd like to thank Mayor Bowser and DOB Director Hanlon for their leadership, and thank all of the DOB Construction Code Development team for their efforts in assisting with this listening session. And with that said, let's get into PowerPoint. So if you take a look at this screen, you can see everything that we're going to cover in our agenda for today. We'll start with a brief overview. We'll move into construction code development process and timeline. Then we'll have some time for feedback on the building and existing building codes, and we'll have our closing remarks. The DOB is preparing to issue regulations to amend and update all 12 construction codes to keep pace with national model code cycles and support safer, more efficient, and more sustainable development across the district. This involves a robust public engagement process. The DOB has kicked this off with a series of virtual listening sessions. These open, facilitated sessions present an opportunity for stakeholders, partners, and community members to share input, raise concerns, and offer suggestions that will help inform our work. And now I want to draw your attention to the construction code development process. This outlines everything that we do. The DOB reviews the International Code Council, ICC, model codes, and drafts local amendments, incorporating feedback from agencies and stakeholders, as well as substantial work completed during previous construction code development cycles. This allows the district to carry forward previously vetted concepts, lessons learned, and community-driven recommendations into the new set of local amendments. Proposed amendments will be published in the DC Register and will then be available for public comment. This is a continuation of the construction code development process to give you an even further look into what all goes into it. After the public comment period has ended, DOB will review comments received and make proposed changes as necessary. If substantive changes are necessary, DOB will publish a second proposed rulemaking that will allow for the additional public comment. If no substantive changes are necessary, the mayor will send the proposed amendments to the DC Council for its review. If the council does not act to make any changes to the proposed amendments within the required review period, the new code provisions will be published in Title 12 of the District of Columbia Municipal Regulations, DCMR. So here we have our timeline. We're currently in phase 1, which is our first notice of proposed rulemaking. As we move into summer of 2026, we'll be holding our listening sessions, the first of which was held on June 25th, 2026, and it focused on property maintenance, swimming pool, and spa. Today, July 9th, 2026, we're here looking at building and existing building codes. July 23rd, 2026, electrical. August 5th, 2026, residential. August 9th, 2026, fuel, gas code, mechanical, and plumbing. September 9th, 2026, energy conservation and green construction. September 24th, 2026, fire. So if you take a look at the dates, you can see that all of them are within 2 weeks of one another. As we move into fall 2026, we'll publish our first notice of proposed rulemaking and then have our first public comment period, which will be 45 days. This is the time for you to make any sort of comments, give feedback, and speak on anything that is of a pressing matter to you, anything that you want us to know, and anything that you feel like we could actually learn from. As we move into phase 2, we'll have our second notice of proposed rulemaking. In early 2027, we'll prepare content for the second notice of proposed rulemaking. Going into summer of 2027, we'll publish the second notice of proposed rulemaking. Have our second public comment period, which will be for a shorter amount of time, 30 days. Then we'll move into phase 3, which is final codes. We'll prepare the final codes, have a council review period, and then in late 2027, we'll publish the final codes. We've now reached the portion of our presentation where we're going to ask for feedback. But just to make it a little bit easier for everyone to jump in, we'd like to start off with an icebreaker. So if you could turn any building in DC into your home or property, what would it be and why?
So, if it were me, I would pick the Heurig House because it already has a brewery in it, and boy, is it a beautiful building.
Fantastic answer. Fantastic answer. So if no one else
We
has,
we have a
excellent.
few comments in the chat. One is the building museum, and another comment was any passive house to save energy. Thank you all for putting your comments in the chat.
Thank you. Thank you so much. Now jumping back into us asking for feedback regarding the current building and existing building codes, we're seeking your feedback on the following: code provisions that work well, should be maintained, sections that are difficult to interpret or apply, requirements that create challenges during design, permitting, construction, inspections, maintenance, or enforcement, and areas where clarification, modification, or additional guidance may improve the code. So if there's anyone that wants to provide their feedback, now is a great time to do so, and we would love to hear from you.
Okay, so the first hand that I was able to see is Chuck Elkins. I have sent your request to unmute. Once you receive that, the floor is yours.
Okay, thank you very much. Can you hear me?
Yes, we
Yes.
have good sound.
Okay, good. Thank you. Well, I had sort of three questions about what you're intending to do here. One is, do you plan to write the neighbor notification into the new code? I ask this because it's in the past it's not been part of the code, and as a consequence, DOB seriously weakened the opportunity for adjoining property owners to review plans before a building permit was issued, and they did that in 2022, and it was done without public comment or review by the council. So I think what what we of the I've got to mention I'm part of the Build Safe DC Coalition, that we'd be interested in having the department build in the old policy on neighbor notification into the code so it can be subject to public comment and review by the council. So one question is, do you plan to do that? Secondly, do you plan to increase the information you receive from applicants when they wish to engage in heavy structural and excavation work? Under the DC code, applicants for a permit to build a 1 or 2 family residences are allowed to make assumptions and not give the department information about the soil conditions at the specific site or the condition of the adjoining walls, as I understand it. And DOB's permitting decisions are highly dependent on the information the department receives from the applicant. So those of us in the coalition believe that the death of the worker at 1113 V Street, a case you and we are very familiar with, might well have been prevented if the department had required the bracing of those party walls and monitoring the movement of the walls before the construction began rather than after the worker died. So the question is generally, do you plan to ask for more information, particularly for 1 and 2 family residential houses? And finally, along the same line, will DOB be requiring that when heavy structural and excavation work is involved in a project, will DOB be requiring that it be overseen by a licensed general contractor? Once again, the death of the worker at 1113 B Street, I think, illustrates the need for that. So I'll stop. Those are 3 major questions we have about this revision. Thank you.
Hey, good morning, Commissioner Elkins. I just wanted to ask a follow-up on your first question because I appreciate the question. My mind started running. What did you mean by is neighbor notification going to be in the code or that it wasn't in the code? I mean, obviously we are going to put, our standards into the DCMR. And at least to me, when I talk about the code sort of colloquially, I mean our whole DCMR. So I was wondering if you could tell us a little more about what you mean by making sure it's in the code.
Well, I'm not an expert in this area, but it was my understanding that it was a rule or policy, but not actually written into the code. My feeling is that this is a case. Neighbor notification is a case where there are important interests on both the part of the adjoining neighbor and also the building construction industry, which would like to get on with building. And so there's sort of a balance that the department needs to make between those 2 interests. And I'm suggesting that should be part of this public comment period and review by the council, because I think I think I'm correct, in 2022 the department just on its own got greatly weakened the neighbor notification process without any kind of public process, including the council.
Good morning, Commissioner Elkins. This is Nicole Rogers. Thank you for your question and your input. A part of this process, right, this particular listening session is on the building code. And while we want to make sure that we gain your input, it's going to be critical here that we make sure we set the expectation and are transparent on how we are going to be reviewing input, the process in which that will occur, and what you've expressed. Thank you. And what we will ask for is that during the public commenting period, you will have an opportunity to truly specify specific areas in the code. If it is, for example, as you noted, neighbor notification, to expand on some of the things that you think would be most beneficial based on your experience. So we will definitely make sure that we keep track of the input that you've provided today, and we can go into additional layers through that public commenting period. So the things that you brought up are absolutely things that we want to be able to review when the time comes for you to provide your formal input.
Okay, we look forward to that.
Thank you.
And really quick, I want to be able to pivot to the chat. So we will go back and forth. Then I'll go back to the raised hand. So after we go through the chat, Shireen, I will then send you a request to unmute your mic. So we have a comment from Anne in the chat that states, I am a tenant at Dorchester House, and I am deeply concerned about the inadequate standards in the code regarding residential elevators. I would like to call from the panel Mr. Parsons. Would you be able to provide some insight to Anne's comment?
Certainly, and thanks for coming, Ms. Pazmanek. I talked to you yes, about a month ago. We are sort of aware of not just you, but other stakeholders who have highlighted the issue of elevators. And I guess I would say the key things to look at when we move into the fall are you'll want to think about the building code is going to be like when you're building a new elevator, and that's one of the codes we're talking about today. And then the property maintenance code is what my team is using to go out and monitor elevators after they exist. And then there are some included standards and standards by reference that our team uses, including the accessibility standards and the like. So we are aware of elevators as an issue to look at this cycle, and do definitely look at some of those particular sections as we move into the fall for suggestions on where we could improve on the models.
If I can respond to that?
Yes, you have the floor.
Thank you. I understand and appreciate that distinction, but I think what I would want to say, and certainly it can be said in different ways throughout this process, I appreciate it being laid out for us, is that our experience is that, one, the standards are inadequate, and what seems to constitute a working elevator does not make sense in real life. So we've had inspections by the Department of Buildings where the inspector has indicated that an elevator is adequate, but that is the same elevator in which somebody has been trapped in the previous week before. So there is a disconnect between what the code requires, what the buildings department is signing off on, and what the experience of a tenant in a building is, especially in our case, people who are in mobility devices, which has been the trigger for the doors closing improperly. So we're very concerned that the code is not adequate for existing elevators, and that there's a problem with the adequacy of elevators altogether. They are seem to be a lot of not modernized elevators in the city. We've talked to tenants across the city who are experiencing the same kinds of dangers and challenges. And just one more comment, if I may, is that it would seem to me, and this is not strictly a code issue, but if we had a stronger language and stronger standards in the code, then landlords would take more seriously their legal obligation to provide a safe environment for their tenants. And perhaps if the landlord here at Dorchester House had been required by the Department of Buildings to provide adequate services, that we wouldn't have experienced the catastrophic event that our neighbor experienced in September of 2025. So would love to see more rigor in the enforcement and also in the code language itself. So thank you for the opportunity to address that.
Understood and very much appreciated, Ms. Pazmanik. Thanks for joining us.
And now we're going to go to Shireen, and then we'll hop back in the chat for David. So Shireen, I have now sent you a request to unmute your mic. You have the floor.
Great, thank you. My question is about the quality of new construction. So I purchased a home in a development in DC built by Brian Homes, and I know they build all over the city. And I had to replace my roof before I even got to the 10-year mark of owning my home. And so I put together a survey and polled my neighbors, and out of about 200 and something people, about 65 of us had some type of issue with our homes, and obviously with the roof specifically. And obviously, because the roof wasn't done properly, it took several years before the leaking to be noticed. I contacted them and they would not honor the warranty. I went through the attorney general, and their lawyer continued to lie and push back. They give us a very generic warranty in the book once we buy the home. It even referenced Maryland. And so when we were working with the attorney general, the lawyer was like, oh, this is for Maryland, and never provided anything for DC. So I guess my questions are around, how do the building codes ensure quality construction? Because I don't think that it is normal that a brand new home would have to replace a roof so soon. And then what recourse is there for homeowners? Because, they're building all over the city. And so I imagine they're using the same shoddy work trying to build quickly, but it's really unfair to homeowners. And obviously, most of us don't have money to fight them and their lawyers in court. So we need the city to have stronger codes and stronger enforcement. Thank you.
Good morning. I can touch on some of that, and I will likely also refer to my colleague for strategic code enforcement. I do just want to make sure there's an understanding of typically the role of the codes when it comes to construction, which generally is to provide the minimum standard. So what it, in many cases, listening to that particular question may not do is require some, I would say, insurance or liability of the contractor. I think that would be something separate. That is something we can look into as DOB, working with our sister agencies when it comes to some of the criterias for general contractors and home improvement contractors to ensure that they're held to the highest standards. Within the building code, we want to make sure that, of course, things are built safe and correctly. Sometimes once a permit is approved, the way that construction proceeds is not as it were approved. Under our review, for which, there are things that we want to put in place, like inspections, and in some cases where special inspections are necessary. Those are things that we can look at in the building code to enhance. But there are other layers, right, where it may involve policy and partnership with tightening some of the requirements of our professionals. And having, I think, the input that you shared is very helpful, because I think you give a different vantage point, right, as a consumer. And that's why we want to ensure that we include safety measures in the building code that not just apply to the structure, but also the consumer. So appreciate your input.
Yeah, I'll just second that. The building code is about building a building that meets certain requirements, and how long it lasts is kind of outside the scope, right? Like, it's legal to build. If you think about the Three Little Pigs, it's legal to build the metaphorical straw house. It's legal to build the metaphorical brick house, and to some extent, we do rely on the market to then distinguish between those and for folks to know what they are purchasing. But as CBO Rogers indicated, we do have our sister agency, the former Department of Licensing and Consumer Protection, does have a consumer protection unit. They do have a practice around properties, and my team in the Office of Strategic Code Enforcement does work with them very often. So we're aware of this issue, and it's definitely something we're thinking about as we move forward.
Thank you so much, Mr. Parsons. Mr. David Maloff, I am now sending you a request to unmute.
Well, good morning, everyone.
Good morning.
Thank you for doing this. This is a watershed and should be a very positive day for our beloved district. We all want DC to grow, and I don't want to be like other neighboring jurisdictions where maybe they're not refreshing the neighborhoods and residences. So I very much trust in what the bigger developers do, and the checkers watch the lawyers, watch the insurance companies, and the major new construction in town really sings in a lot of ways to me. But the neighborhoods have become a backwater, and the neighbors, many of whom, because of adjacency and abutment of joint ownership, have become prey. And we have to recognize the constitutional property civil rights embedded in the Constitution to own private property and to have it respected. And respectfully, DOB does not possess the eminent domain authority to transfer property wealth, property ownership, or negative externalities that cause harm, damage, and even injury onto unwitting neighbors. And it's always 5% of the problems that cause 90% of the headache. We need to get beyond this. Kim today in her chat, and I think another gentleman, recognized that there are these abutment issues. We need separate attention, separate unit, and separate recordation for the dangerous stuff. What happens with plumbing and electrical is not a problem. What happens with adding load onto an old teetery structure, digging under another person's home, and leaving who knows what with what quality of care and materials, and inserting new load from above. These are the flashpoints. And, everyone's welcome to develop their properties to refurbish. But when we get beyond kind of clever prudence and get into wanting to stick something like the Finger building on about 1015 V Street Northwest in the middle of a row, that gets dangerous. And a lot of the people running around this town are not qualified. So DOB needs to redouble after 4 years of the walking wounded walking around this town who've been suffering. You need to probably focus and put back into the code what was formalized. DOB lost 2 cases in my case at OAH, and both judges reaffirmed that the neighbor notification program, highly detailed and I think beneficial to encourage dialogue prior to permitting, was settled administrative law. It's always a problem with administrative law that the agency that has the expertise goes beyond, rightfully, what's in the code itself. And so when you start doing things that are necessary and structured and they become settled, you can't go back later and say, oh, well, it's not in the code. It was in the code. Everything was required as a part of neighbor notification. So I think we can get all beyond this. I submitted 7 documents yesterday. This statement, detailed initial comments, and 6 attachments. Those are available to anyone who's interested. My email is mallof, M-A-L-L-O-F, at verizon.net. I'll repeat that, and I'd be glad to engage with Kim or anyone else on this. And I think also, if you could, I'd like to know exactly who's going to come up with this first draft. We're covered under the DC APA, which is a mirror image of the federal APA. Arguably, both of them kind of apply. And this period now of hearing people and then coming out with the first draft, the first notice is critical. And in fact, if you get no big comments, then it goes right to the council lickety split. So the concrete is already sort of curing when the first notice comes out. This is a little bit of a mystery to me now because we don't have CCCB anymore. I'd like you don't need to do it today, but I'd like you very specifically to identify who are the decision makers. I know it's going to be a lot of people, Josh at OAG and a lot of other people inputting to you, risk management and so forth. But in the end, whoever the key decision group is that's going to birth this draft that will be put into the register, I think we need public disclosure right now of who the key and responsible decision makers. In fact, the code officials who are responsible for producing it. So that's that. Again, my email is mallof, M-A-L-L-O-F, at verizon.net. And if those of you can see the background, I know a lot of people can't see the background, but that's 1113 V Street. And it's well worth us keeping in mind during this process. Everyone needs to be safe. And that was not an unusual situation. That situation lives in us still not addressing all the problems procedurally and managerially and in inspections that gave rise to that. So I'm welcome to accept a call or an email from anyone. And thank you so much for doing this. This is a great day for us. And let's move on. I want the big stuff done in this town, not for us to worry about individual properties and hold the process up. Thank you.
Definitely. And thank you, Mr. Maloff. And as we discussed, we did receive all your documents. Just for clarity for folks, the comment period will open in the fall, which is when submissions like that will be sort of implemented into that. Right now, we're in the listening session phase. So Mr. Maloff is ahead of the curve on this process, but we definitely appreciate that, and thank you. Ashley, you want to
Yes.
go on?
Yeah, so really quick, just regarding our feedback session, just to make sure that everyone has a even amount of time to express their comments. We just want to make sure that our comments and our feedback today are related to code provisions that work well and what should be maintained. Also, sections that are difficult to interpret or apply, so we can possibly help you clarify that today. Requirements that create challenges during design, permitting, construction inspections, maintenance, or enforcement. And lastly, we really want your feedback on areas where clarification, modification, or additional guidance may improve the code. All right, so as we get through that, we are going to move on to Melinda. Melinda, I have sent you a request to unmute. You have the floor. Thank you so much.
Good morning. Thank you. Thank you, Department of Buildings, for hosting these listening sessions. I'm Melinda Freevert. I am the president of the Dorchester Tenants Association, neighbor of Anne, who spoke earlier. Also, just want to acknowledge, again, really appreciate this forum. This is government at its best, meeting people where they are at to talk about issues that are really important. And what is more important than the homes that we live in every day and spend so much of our time, and where we all want to feel safe. So on that matter, I know we've spoken before about elevator safety. A couple of things I want to bring to light in the code that have stood out in our conversations with you and in our conversations with our tenants in our 395 unit building. The code part that says doors should automatically close after a certain number of attempts causes significant issues for our neighbors' immobility devices. Their chairs have been damaged. I experienced an incident on New Year's Eve where a door was going to close on a neighbor's legs, even though they were in the elevator door. The only thing that kept it open was pushing the door open button. I don't really understand why a door would close at all if it is detecting an obstruction in the door. So I think that is worth addressing. I think also the timing of how quickly doors close. I know you all rode our elevators with us, and we even timed it. The particular issue we face, and that I expect is common, is, because we're an older building, our elevators were not designed with accessibility in mind. Our tenants and mobility devices need more time to get on and get off. Like 30 seconds is not enough, and I would gladly wait another minute for an elevator if it meant that my neighbors and mobility devices are not having them damaged or worse. And then lastly, if this is part of the DOB code, one of the biggest issues that we've heard from folks around the city and that we know is a struggle is the requirement that only one elevator be operational in a building, that's the bare minimum. We are a 395 unit building. We have 4 elevators, 3 main ones and a freight one. If we were down to one, like we're down to 2 elevators that are in operation, and it runs tight during peak times. And if you're in a building with hundreds of units, one elevator is simply not enough for a regular day-to-day basis. So those are definitely some changes I would propose and love to work with DOB on, particularly making sure that the perspectives and needs of folks in mobility devices are accounted for, because let's be honest, disability is coming for all of us. So thank you.
Yeah, thank you very much for that. And as I said on the prior comment, or the prior feedback, just look to the property maintenance code for the operational number of elevators, and the accessibility standards is where you're going to see the operational thing. So as we go into the fall, those are what you'll want to look at.
Thank you so much for that. So I am going to go back into the chat. Cindy Davis, I have sent you a request to unmute your mic. You have the floor.
Thank you so much, and thank you to all of you for putting these listening sessions together. They really are helpful, and just want to give a shout out and a kudos to all of you for doing it. It's a lot of time and effort, and it's much appreciated. I am representing the Apartment and Office Building Association of Metro Washington, or AOBA. AOBA does support cost-effective and technologically feasible improvements to building safety, performance, operational efficiency, and sustainability. However, changes to these standards, especially for existing buildings, must balance these aspects with the need to preserve the affordability of rental housing and minimize excessive burdens on commercial office buildings that are still struggling in a post-pandemic environment. So just wanted to put that on the record. And again, thank you for your efforts here today. Much appreciated.
Thank you so much for your feedback, Cindy. We are going to now go to Liz. Liz, I have sent you a request to unmute your mic. You now have the floor.
Thank you. I'm an architect practicing in DC, and I just have a few kind of two separate points and questions that I'd like to make. Firstly, recently the One Front Door Act was passed by council, and I was wondering if that study and potentially the implementation of the single stair in smaller apartment buildings, is that something that will be incorporated into this code update? Or is that the plan, I guess?
I can share that it is something that we're looking into. As you know, there was a separate legislation that you referenced, which also has specific timelines. But I can share that we are reviewing the information that was shared. There was a hearing also in reference to it, which gave a lot of great testimony. So we're taking all of those things into consideration.
Okay, thank you. And then my second question is on accessibility. Will we also be including the updates to the 2017 version of ANSI and those standards, which is great that they're more universally accessible, which I think will be a big improvement. And also wondering if for apartment buildings, so R2 use, will the percentage of type A units still be at 15%, and kind of want to know where that percentage came from, knowing that IBC is at 2% standard, and then obviously we jumped to 15% in DC. So.
And those are excellent inputs. The reason why we want to have these sessions is to listen to you all, right? And understand kind of based on your experience, what we can do to make the next code provisions more efficient and practical. So that input is going to be super helpful for us, and strongly encourage you when we do go through the commenting period, the public commenting period, that you provide that as a comment.
Thank you so much, Nicole. I'm now going to send an unmute request to Ms. Kim Preddy. You have been sent your request. You now have the floor.
Hi, good morning, everyone. How are you guys? Hello, my panel. Hi, Nicole. Hello, Keith. Hello, Peter. Hi. My comment or my concern is regarding existing two-family flats that are existing in the field, but not existing on paper. In my going on 25 years of expediting it, I've probably done at least 200 properties where they are built classic two-family flats, but they do not have a CFO on record. So once that property goes to get transferred between owners or even go through renovations to make updates, we encounter the problem of the project getting sent through permitting, and then it is looked at in permitting as a brand new two-family flat and not one that is already existing with fire separations, with egress, with two Pepco meters, the whole 9 yards. And that typically tends to trigger a renovation that is unattainable for a lot of people, unaffordable for a lot of people. It then snowballs into preventing people from getting their business licenses and doing their housing registrations when the city needs housing so badly right now. I've had situations where an inspector might come out instead. It doesn't happen often. It's happened maybe twice where phone calls were made And instead of us having to go through the entire permitting process, an inspector comes out, they look at the property, they make sure that it has all the requirements by code to exist as it is existing as a 2-family flat and not considered a single family dwelling. And then the CFO is issued. So what I am looking for is some kind of clarity in the code, so that when this situation arises for an existing building per se, if the code says projects or existing 2-family flats without recordation, if it meets these requirements, A, B, C, D, list them out, boom, and then follow up with an inspection, I think it will save a lot of time, resources. These projects, something simple that already exists, ends up taking months to get a permit, as opposed to a process that could be broken down into 2 weeks. It was a little bit easier to get these things resolved when we had in-person services, but we are in the world of digital now. And I just think it would be easier across the board if it was written in the code on paper, black and white, so everyone would know how to proceed, instead of leaving so much room for interpretation or misinterpretation and varying or inconsistent requirements to get the same thing done. It shouldn't be that hard. We all know DC has a lot of houses that were built as 2-family, and they've been like that for 20, 30, and 40 years. So they don't have any CFOs. And we should do something to fix that. That's all.
Thank you, Ms. Preddy, for your input. And I think some of what you noted as far as recommendations are things that we can do on the policy side, that we can definitely work with our zoning partners as well to make sure that if it is already a property that has the additional units, that it meets some of the major fire and life safety things. There are ways that we can verify that without necessarily going through the full building permit process. So appreciate your comment and recommendation on that, because I know that those scenarios come up a lot, and sometimes we verify them through inspection. And it would be great, again, through the public commenting period, if there's a particular provision within the existing building code where you want to highlight this, for you to provide your feedback there. And again, open to other recommendations as well to help improve and streamline the process outside of the code requirement or changes that just help to improve timing and make it easier when these are uses that are technically already existing, but may not be recorded as you stated. So appreciate your feedback and input.
Yeah, I'll just add on that everything that CBO Rogers said, and don't miss the fact that the code is, on the one hand, the actual standards for the buildings, and it also includes, as we were sort of talking about with Commissioner Elkins at the very beginning, the whole Title 12 regulations that DOB uses. So some of these things, and the last question about the 2-family flats kind of comes to mind in this, are more in a space of the way DOB is sort of behaving about the code, right? That building exists. You go out there, you look at it, it looks like 2-family flat, it has 2 meters, et cetera, et cetera. What do we do when we find that is also a question to think about. And obviously, both my division and CBO Rogers division are really intensely aware of how the code does directly impact the way we work in our day-to-day work, and the way we work for you, and the way we protect the district's built environment. So thank you for the question.
And if there is any feedback anyone else would like to give, please raise your hand so we can send you an unmute request. And just remember, please keep your comments and feedback to 2 minutes. Okay, Chuck, I have sent you a request to unmute. You have the floor.
Thanks very much. This may be another one of these things where it's the regulations versus the code, and you could give me some guidance in that regard. It's a problem that we see in the neighborhood frequently. It's when a person is supposed to apply for a raise permit and when they're supposed to apply for a renovation permit. And what we have is people will try to avoid the raise permit because it takes more time. They have to have the utilities do the whole review. So what we have is builders who leave one wall standing, and then sometimes in the middle of the night that wall disappears and we have a total raise, but of course it was called a renovation. My point is this, that if utility review and historical preservation review is necessary for a raise, why isn't it necessary for a case where you leave one wall and tear down the whole rest of the house? In other words, this distinction between a raise and a renovation, I think, is sending strong motivations to our contractors to try to skip through it. And so is that a regulatory problem, or is that something we could fix in the code?
So I can mention in the IBC, Chapter 2 is definitions. And I think you bring up an excellent point, which is something, the difference between a raise, a demo, interior demo, all of these things are defined in the building code. And this is a great opportunity to help clarify what those mean, so that there is clear distinction. So excellent point. And it's something that I think across the board could use clarification. So yes, this is an opportunity to be able to elaborate and include distinctive definitions.
Thank you so much for that follow-up, Nicole. I'm now going to send a unmute request to Will. Will, it's been sent. You now have the floor.
Good morning. My name is Will Tays. Thank you for putting these sessions together. I think they're really valuable, and I appreciate the opportunity to contribute. I think I just wanted to put some notes in the chat, but I really wanted to call attention to some of the lot line issues, in particular chimney extensions and snowdrift, where oftentimes that process, which is related to the neighbor notification, has been weaponized, and it prevents homeowners and others from doing or taking on as of right vertical development. And there's some clarity, I think, both required in the code, but also I think in how the code is interpreted and applied. And then I think I concur with the raised comments as well, just providing some clarity there. And then also I think what we're seeing recently is a trend towards more revisions to active building permits as a result of site conditions. And I think that as it's currently, as the section's interpreted and applied, there's some challenges there in terms of when it's required, how it's done, and ultimately I think has the potential to really clog up the system. So with that, I'll turn it back over to the panelists. Thank you.
Thank you, yeah, for this for that feedback, and know that we are very cognizant. Director Hanlon's motto is safe, green, and moving, and the safety and the moving are both very important. So we we are very much thinking about how the standards we put in the code are going to impact the way permits and processes move through our system.
Thank you so much for that follow up. I'm going to go to a comment in the chat. DW asked or made a statement of saying, will DC DOB provide information regarding what current amendments are being evaluated in more detail and consider if they should be carried forward or further amended?
I mean, the short answer is yes, but in the fall. Am I correct there? But yeah, the fall we will have the full comment process, and that will be where specific comments can be submitted to specific parts of the code, and all of those will be reviewed. The process will move forward.
All right, I'm looking to see if we have any more hands raised in the chat. Okay, great. Nev, want to pass it back to you. This has concluded our feedback session.
Thank you so much, Ashley, and thank you all for providing your feedback. Just want to draw your attention to our list of upcoming listening sessions. Our next one will be on July 23rd, 2026. It will focus on electrical. There's a QR code down at the bottom of the screen. If you scan that with your phone, you can go ahead and register for that one as well as any others that might be of interest to you. We're looking forward to seeing you at all of these, and we're hoping to hear much, much more from you. With that being said, we'd like to thank you all for coming out. Your feedback was greatly appreciated, and it will inform our work. Please feel free to connect with us through any of the avenues that you see featured on this page, and have a great day.
Thanks, everyone.
Thanks, y'all.